Welcome to SME TV. I'm your host, Angela Vithulkas. The COVID-19 pandemic has seen many small businesses pivot. They've created new ones, or they've even expanded on their existing ones with new ideas. But are these new ideas safe? Well, please remember to subscribe to our YouTube channel so you can look after us and all SMEs, and you can check out some of our other great interviews. So are all businesses safe? Well, joining us today is Binh Rey, Trademark Attorney from Baxter IP. Welcome, Binh.
Thank you, Angela. Thanks for having me.
This is a huge question, isn't it, right now? I think right now is more impactful and vital than ever to know your rights on protecting your IP or your trademark or your patent, and we'll get into that. But right now we know that businesses have gone, oh no, my current business model isn't working, I need to pivot. And they've expanded in ways they weren't ready for. They've probably grown their business in another direction, or they will, and they've forgotten or overlooked the fact that they might need to protect themselves. And in order to do that, they've got to register either their trademark, their IP, or their patent.
That's correct.
So let's cover off briefly, what is your trademark, what is your IP, and what is a patent?
Okay. Well, a trademark and a patent are a collection of intellectual property that a company can own. A trademark essentially is the brand of your business, or it could be a product or service within your business. And a patent is protection for your invention. So I don't know if everyone knows this, but an interesting fact is that Wi-Fi was patented by CSIRO in 1996. They had 20 years of monopoly of that technology. And I think a couple of years ago, it said that 5 billion devices have Wi-Fi or using Wi-Fi. So if you can imagine, if the Australian company didn't patent that technology, they wouldn't have obtained any royalty or revenue from that one technology. So a patent actually protects you for the invention of a product that you can then...
Does a patent run out?
Yes, unlike trademarks. Trademarks you can renew every 10 years and it can go on forever. However, with patents, limitations about 20 years around the world. And you've got to apply for a trademark or a patent per country. So there's no such thing as a global intellectual property, registration. You have to identify the countries that you want to, enter and do business in.
So it would take quite a feat to register your patent worldwide, which you would have to do if you're inventing something. So it sounds like, it sounds like it could be a big payoff down the track, but it mustn't be a cheap exercise.
No, it wouldn't have been a cheap exercise. So a lot of times companies would, first of all, make sure that their brand is protected. For example, Apple, they would have protected their brand first, and then they would have looked at what patents do they have, within the technology of their computers to patent. But the brand is the foremost that valuable asset of a company, because that is what the consumer sees. The consumer doesn't see what's inside the computer, they see what the brand is. And you don't go around going, oh, well, I love that technology in the Apple computer. We go, well, we want an Apple iPhone, or a Samsung iPhone or something. So we identify the product with a brand name, and that's where trademarks are very important. And
so we'll come back to using Apple as the example.
Yes.
Because we've spoken briefly off air before on how to gauge a trademarkable brand.
That's right.
Taking liberty with the English language there. Look, briefly, before we get to that.
Yes.
There are some businesses that don't need a trademark.
That's correct.
Okay, so let's cover off on that so that we can clear that up for people.
Sure.
Who doesn't need a trademark?
Well, companies that don't mind if another company comes around and says, you're infringing on my brand and you must stop, using this brand. And if that business owner says, okay, that's okay, I'm happy to rebrand, then they don't need a trademark. Okay. The second reason why you wouldn't want to need a trademark is even if you got the trademark registration and the business owner doesn't have the appetite to enforce the trademark, then you might as well not have gotten that trademark in the first place, because without stopping someone from using your trademark registration, you're actually allowing them to use your brand and accrue honest concurrent use. So why would you have gotten the trademark in the first place? Okay.
So check your motives.
That's right.
Do I need to really have a trademark for my business or my brand? If I never intend to enforce it anywhere or monitor it, then it's a worthless exercise.
It is.
Are there some instances where you can't trademark your brand?
Oh yes, there's many instances. If your brand is descriptive, if it's a popular surname, if it's a geographical area, or that it's offensive. So,
okay, so offensive is important.
Offensive is very important as well. So later on, we might be talking about, I'll have some examples of COVID trademarks, but COVID could end up being an offensive word in the marketplace because everyone's going through lots of trauma during this period. And, you know, to create a brand around this name and to remind the public about COVID, it may not be well, first of all, it's not a smart thing really to market a product that
it doesn't sound like a smart thing. You touched on the fact that if you have a popular surname, so if my surname was Smith,
yes,
which clearly would be it's a popular global surname, I couldn't actually trademark my name.
No, unless it's your name or you were lucky enough to have sort of started the business in the 1950s, where trademarks and came from is that supposed to tell the people the origin of the product or service. So back then, without the internet, in your community, the only way people can identify you is by your surname. So of course you've got the McDonald's and the Smith Chefs and O'Brien tires. It's because
Vegemite.
It's just the way the trend was. But with the advent of television, internet, you can get more creative, and that's how the brands have evolved. So with trademarks, rules can change. So maybe in the 1950s, it was acceptable to have a trademark as a surname as a trademark, but now it isn't because, there's more population and also the rules have changed about trademarking.
So I'm assuming that's another reason why you actually do need a trademark attorney.
Yes, because rules change all the time. Yes, and even when you get a trademark, you have to review it every few years. It's like anything. People get the trademark, they put it in their filing cabinet, and they forget about it. Yeah. So when we talk about pivoting, I'll answer the question about pivoting. So a lot of our clients have pivoted towards other businesses because the traditional way of making their revenue has just evaporated. So we've had builders turn to the internet to offer online training for the mums and dads or small developers to say, hey, do this training. We'll teach you how to buy land, subdivide, consider all these factors. So the building company is now selling online training. So that's a complete pivot to something that they wouldn't have offered previously. And the reason for that is that they need to look for extra revenue, and the internet is a way of attracting customers because we can't meet up anymore.
Would they be under the assumption that their original trademark would protect them for their new business model, but in fact it might not? Or simply...
you're correct. So the building class is separate to a training class. So if they did own a trademark in the first place, they need to review the trademark and maybe add training as part of their protection. And I think it's been widely reported, a lot of distillers, like we've had a gin distiller sort of turn to making hand sanitizers.
Hand sanitizer, yeah, because it's alcohol.
That's alcohol.
Who knew that what you drank could actually, kill germs?
And what we had found was at the beginning of COVID, things started drying up because everyone was very concerned about their cash flow. So March was a bit quiet, but then we saw April sort of, increasing inquiries, only because people were starting to be creative about what they're going to do. And then we're seeing that the inquiries have gone up in May and June because the confidence that COVID is subsiding is going up. But also, I think because our behaviors have changed, what we're finding is that a lot of people that are offering counseling services,
yes,
previously wouldn't have imagined that they could counsel their clients over Zoom.
Right.
Because it's something that's foreign. You're supposed to be in a room with your client or your patient.
Your patient, yeah. Well, look at us. We would normally be in studio.
And so a lot of these psychiatrists, counselors, coaches, they're actually now pivoting online, and they're looking at trademarking their brand overseas because they're obtaining overseas clients. So now they're going, wow, I can now market myself in America for my specific training program.
So we're saying that off the back of a global pandemic, with people assuming that they were just pivoting to adjust their business model to kind of hopefully maintain their revenue or their cash flow, they're also now having to address the fact that perhaps they've hit on a new business model.
Yes, that's right.
And protect it at the same time. And there's a silver lining here with the global pandemic in that we've had to adapt in different ways, change what we were doing. We use the word pivot very, very loosely and throw that out frequently now because that's what everyone's done. We've had to backflip, rethink, recalibrate. All those are good things, but it also means that there's more paperwork involved.
Yes.
Again, why you need to go to the specialist of a trademark attorney.
Yes.
It's not something that you can do yourself because even though the rules can change, it's still very difficult to understand and adapt.
And it's actually really important now to actually see someone instead of doing it yourself. Is you don't know what you don't know. So you may think that something is unique, but we might look on the global whiteboard database and find that you can't use that. Yeah. And therefore, what you've created in Australia, you've got to rebrand again if you're going to go to America. So it is important that that you do see someone and someone that actually understand branding as well.
So it's a worthwhile undertaking, but you have to understand what you're up for. Yes, and just because your company in Australia is, called Bananas and it's doing amazing, doesn't mean that name is going to then be able to be trademarked globally. Mm-hmm. And you might be switching to strawberries sooner than you think.
That's right.
Loosely speaking. Yes. Before we look at some of the brands and how they've trademarked themselves and how easy it is to enforce it, because that's the thing on the strength of your trademark. What's the number one? Talk to us about the number one false belief about trademarks.
Well, because we've got the small business membership watching this SME TV, the number one false belief by small businesses is that their company name or their trading name protects them for their brand. So many times I have people saying, I didn't know that my brand was not protected. My accountant told me that I got the company name through ASIC. Therefore, the way I go, start my business, start building it, and then find out later that there's no protection except for passing off laws, which is under the common law. But that requires you to court straight away. But if you have a trademark, you actually have the legal right to ask the other party to stop using it.
Right.
So that is the number one false belief, that if you actually really value your brand and you really believe that the business that you're starting up is going to succeed, it's best to file it at the very beginning of your business, because you need to be first to file and you need to be first to use it. Because there's no point to be first to file, but there's a brand out there. So you need to check both aspects of whether that brand is available. And a quick Google search is sufficient. If you type in the name that you want and you find another party in another state using it, well, forget about it. Move on, find a new name. Why would you headbutt yourself against the wall or come up with something that's already been used? Even
if you are first to file, it's not an overnight end though, is it? Because it takes time.
Yes, in Australia it takes about 8 months to get a trademark. Yeah. Overseas it takes 12 months. So you've really got to plan as well in advance. And the big companies do that. They have to, because they have to, yeah. They have to. But the small business actually should just take a step back. I know everyone gets excited about, I want to start a new business, but just take a step back and go, let's do a little bit of research of the brand name, and you've got nothing to lose. So you come up with something. If it's not available, well, you haven't spent any money. Just change it.
I know. I love the part. I love the part that you said. Just move on.
Yes.
It's that's that simple. It's taken Move on.
Second.
And that's important, Binh, because it's before you become emotionally invested in a brand or a name or a dream. I mean, and let's use Apple as the example here, because who would have thought that you would call a computer brand Apple? Every marketing philosophy that you read where the brand needs to reflect or the name needs to reflect what the product or service is flies in the face of the Apple brand. So, but as you said, we've spoken briefly before, that because it's such a unique name, it was easy for them to also track and enforce.
Yes, that's correct. I mean,
so another reason why you should think about the name from a trademark perspective.
And sometimes I find that there's so many motivations of why people get a trademark. There are people out there that get a trademark, they don't actually care if someone else uses it, as long as the other person or the other company doesn't ask them not to use it. So that's another motivation as well. So there are many motivations, but I think that for me anyway, doing this since 2012, they need to really have the appetite to enforce it. That's one thing that I like to ensure that people, that if you're going to get a trademark, you've got to be actively enforcing it. So, which is
a good tip to remember. If you're going to do it, question your reasons why.
Yes.
And what that path looks like from there forward. What about some quick tips for people who are just getting started? We mentioned, you already said, do a quick Google search online before you become invested in the name. Any other quick tips they should worry about?
Well, when you're creating a new name, you shouldn't have something that's descriptive, okay? And I know a lot of SEO companies say you should, but what if you're Melbourne buyers advocacy group or something? I mean, all the other buyers advocacy groups must have to use Melbourne advocacy or Melbourne buyers advocate. So if you're going to go down that track of having that name, you have to expect other people to use it, because you're in Melbourne, you're a buyer's advocate. Other people should have the ability to also call themselves that or describe what they do. So avoid descriptive names if possible, if you want to be unique in the marketplace. Because I understand the SEO side, being on the first page of Google, but at the same time, if you want to differentiate yourself and your service, actually having a unique name is better for you, because when you type it in, you'll be the only one popping up instead of all the other people that pop up with you.
Apple being a classic example.
Yeah, that's right.
It wasn't
if they were just called stylish computers, how many stylish computers are there? Everyone thinks that their computer looks stylish or, really nice.
Binh, we are running out of time. What I do want to make sure we include in this is some of the funnier stories to come out of trademarking. And we mentioned briefly in the beginning of the interview on how offensive words, you can't trademark offensive words. And it could be in the future that COVID could be categorized as an offensive word, given that there have been so many deaths around the world.
That's right.
But you've come across some interesting names that people have tried to trademark.
Yes. So I did a bit of research this morning, and there's currently around the world, there's 369 applications for COVID-19 or variations for clothing. I mean,
like COVID jeans, you said?
Yeah, COVID jeans, COVID wallet. Someone wants to trademark COVID coins. I mean, why would you want to handle money for COVID coins? I mean,
when we've been told that it spreads germs, cash spreads germs.
There's a machine that someone wants to call, testing, and it doesn't sound right to me. COVID confirm, like you would hope that you're not going to get COVID. So to go to, to market a machine to say, come and get yourself tested by the COVID-19 confirmed machine doesn't really make sense, but someone has applied for that as well. There are some obvious ones like Stop COVID. I mean, if we can't even get a vaccine, does that really make sense? And can they really legally get a trademark for it? Because no one can stop COVID.
Well, everything that you said during this interview would imply that you probably wouldn't be very successful in trademarking Stop COVID.
No, you wouldn't, because two things: it's fairly descriptive, and it doesn't make sense. And at the moment, it's hard to know the position of all the examiners around the world, because as I said, it does take a long time to get a trademark. So a lot of the applications actually started being applied for in February and March when COVID started.
Yep.
So the examination isn't going to be until later later in the second half of the year.
And that's
we're expecting.
That's how the evaluation happens.
Yeah, the examination will happen around the 6 months to 8 months mark. But we believe that the majority of these COVID applications won't get passed by the examiners around the world.
Well,
it is traumatic. I mean, there was I think when SARS happened, or September 11, anything that sort of had those traumatic events, there was a surge in trademarking those brands, but I think it's a trend. It could be a fad. It'll come and go. I mean, who remembers SARS now that we've got COVID-19?
Well, but it's gross.
Yeah, it's gross.
It's something that's offensive, and therefore hopefully wiser people prevail in the examiners and the examinations of it all. Have you got any data numbers you want to share with us on countries around the world where the
I'd like to share with you, actually. I'll just bring my figures up. About the I'll mention that IP Australia is actually launching a SME portal. Right. So IP Australia is the government body that gives out trademark registration and patents. They're going to be launching a SME portal, more mainly for the patent.
For inventions, yes.
Because patents are very complicated, much more than, I guess, trademarks. So if anyone's interested in finding information about that, I'm happy for them to contact you, and then I can pass on the link. And it's really more to educate them about what they need to do before they see a patent attorney. Because as you know, every time you see an attorney or anyone in the, it costs more. So if you can sort of educate yourself prior to that and be more distinct about what you want.
And line up all your ducks, take all the information you have, because it'll make the application smoother and faster.
Okay. So the figures I wanted to share with you was that throughout COVID, it hasn't been that drastic in Australia. The filings have only dropped by 5% on average, okay, in terms of the filing compared to the same period last year. But the interesting data is that 2 states have sort of gone against the trend. Tasmania, their applications have been up by 5%, and with patents, so it was up by 9% for trademarks, but in Tasmania, 50% increase in patent applications. So
they've been busy inventing in COVID.
They've been busy inventing in Tasmania and in Queensland as well. So that's the interesting data that came out of the IP Australia report that recently was published. So it seems like Australians are very optimistic during this COVID period, being very creative and thinking about protecting their intellectual property asset, because I guess there's a smaller market for the revenue out there because the economies have contracted, and therefore the best protection of your revenue if you're going to launch a new product or brand is to get legal protection for those 2 intellectual property assets at the very beginning, because it sets your business on a solid foundation to move forward without thinking whether someone's going to come after you for infringement of trademark or patent brand registration. So it's really important that people think about that. And it is a cost, and it's a cost that's fairly worthwhile.
But it's an investment.
It's an investment.
It's an investment in protecting your brand.
That's right.
And who doesn't want to do that? Thank you very much for joining us, Binh, today. The information has been invaluable. We appreciate the updates as well with IP Australia launching a brand new portal.
Yes.
I'm sure the SMEs will be very interested in that. To all our watchers out there and subscribers, if you haven't subscribed, please do, because supporting SME TV means you're supporting the SME community. If you have any information you'd like to share with us, you can email us, news@smea.org.au, and of course, we're across all the socials. Binh, thank you very much. I'm sure we'll be speaking to you again.
Thank you. Thanks, Angela.
Thank you.
Okay, bye.